Welcome back to one more session of Vicky Lawdition. Today in this session I am going to explain about introduction about the Hindu Succession Act. Proposals for reforming the Hindu personal law, particularly relating to property, have been before the country in one form or the other since the forties and the setting up of Rao's committee to inquire into and suggest reforms in the Hindu law. The question of codifying the Hindu law of succession was engaging the attention of the government since 1941, when a committee was formed which is known as Rao's committee was formed to report on the desirability of codifying Hindu law and more particularly to examine the Hindu women's rights to Property Act 1937, to examine the Hindu women's rights to Properties Act 1937, to remove the doubts as to the construction of the act, and so to remove any injustice that might have been done to the daughters. The Hindu Succession Act 1956 received the assent of the President on 17/6/1956 and came into force on the same date. The Act has not been given extraterritorial jurisdiction like Hindu Marriage Act, as under the principles of private international law. Lex loci governs the matters relating to immovable property. The act is not extended to the state of Sikkim. So, the old Hindu law under which married daughters were not entitled to inherit the property of her father is still applicable in the state of Sikkim. For this, there is a reference, that case Krishna Chandar versus Balkumar, AAR 1993, Sikkim 5. So in this particular case, it was held that married daughters were not entitled to inherit the property of her father. Similarly, Christians in the state of Pondicherry also continue to be governed by Hindu customary law of succession. For this reference cases, Pauline versus Jerome, AIR 1977, Madras 270. Provisions of the Act are not applicable to members of scheduled tribes. Gola versus Board of Revenue. In this particular case, it has been held that widow after remarriage has no right over land of her husband. This is the act related some exceptions. The main object of the Hindu Succession Act was it has been passed to meet the needs of a progressive society. It removes inequalities between men and women with respect to rights in property, and it evolves a list of heirs entitled to succeed on intestacy based on natural love and affection rather than on religious efficacy. This is the main object of the Hindu Succession Act. Some of the important and main features of the Hindu Succession Act are: the act applies to all Hindus, Buddhists, Jains, and Sikhs, but not to Muslims, Parsis, Christians, and Jews. It has further been extended even to those persons, one of whose parents is a Hindu, Buddhist, Jain, and Sikh, and who is brought up of as a Hindu under Section 2 of the Hindu Succession Act. One of the most important features of the Act is that the right of a Hindu female to inherit property has been fully recognized, and she has been made entitled to a share equal to the male heirs. Women's limited estate has been abolished, and whatever property has been or shall be inherited by a Hindu female will be or shall be her absolute property. The Act has given an important place to Hindu females in the classification of heirs. The Act has abolished impartial estate and the special mode of its succession. The Act does not apply to the property of a person who has contracted marriage under the provisions of the Special Marriage Act 1954. Those who are perform their marriage through Special Marriage Act under contracted marriage, for them this act does not apply, even they are Hindus. The concept of co-partnership has undergone a change in the sense that succession to co-partnership property was governed by rule of survivorship. In this rule, the female heirs did not have any place, and the property on the death of a male heir devolved upon the rest of the male members of the co-partnership. Now, under the Act, the rule of survivorship has been abolished. The Act provides for four categories of heirs, the first of which is Class 1 heirs, which consists of 11 female heirs and 5 male heirs. The order of succession provided by the Act is based on the concept of love and affection. The rule of preference based on right to offer pinda or propinquity of blood has been discarded by the Act. The Act makes no distinction between male and female heirs. Murderer is not entitled to succeed to the property of person murdered. The Act entitles a male or female Hindu to dispose of his or her interest in a Mitokshara co-partnership property by will. This is a brief introduction of the Hindu Succession Act. In upcoming videos, I will give a full details on this particular concept with the help of classification of heirs and with respect to various problems. Thank you.